each of those topics briefly here. Non-marital property is reduced to common sense terms or common usage terms as whatever you came into the marriage with, you're entitled to leave with. Among these things would be certainly if you owned real estate at the time of the marriage, you are entitled to take that or be awarded that real estate at the time the marriage breaks up. The same would go for any type of property. The trouble is that most marriages that after a little bit of time, all the property of both parties is commingled to the extent that it's hard to determine who owns what property, or if any of it can be attributed to a single person. Then it becomes at that time marital property. Marital property also includes property that you have acquired during the term of the marriage, things you bought together, things you have used joint funds to buy, or things that, although it may have come from one person's payroll or assets, the other person was paying other debts, other expenses of the marriage. So anything that the parties buy together or accumulate together becomes marital property. These seem to be not very complicated terms, but they can, through the course of a marital dispute, become very complicated and get very involved in trying to determine who is entitled to what property and how it should be divided. Along with the separation of property goes the assignment of debts. In most cases where there is a dissolution of marriage, along with property, there are certain debts, such as mortgages on the house or farm property, loans on the cars, consumer credit on various items of property. These debts generally will follow the property. For example, if one of the spouse should get the car, then he or she should also get the debt which is secured by that vehicle. It is I am not trying to sit here today and say I can give you all the answers on how property is to be divided. That is handled in every case differently. Each case stands on its own merit. Each attorney goes about things differently as to how to advise you to divide the property. What should be kept in mind the whole time that you're going through a dissolution proceeding is that the court is interested in a fair and equitable separation or division of this property. If you go in with the attitude that this divorce was not my fault, I'm going to make the other person pay, then what happens is that the system basically doesn't work. You cause extra time for the court system, you cause extra time and trouble for your attorney and for your spouse's attorney, and as was explained earlier, fault has no place in the determination of division of property. Since this is a general information service provided to the public, I'm put some editorial comment into it in that the idea of cooperation and assistance will help you and help your attorney in representing you in the event of any dispute over property. Also to be discussed is the issue of maintenance, and as was discussed before, fault is the only time you can discuss fault is when you're talking about maintenance. And maintenance / alimony is not a usual topic or a usual relief in most dissolutions of marriage. Maintenance is practically an extraordinary relief. It comes about when one party, because of the term of the marriage or certain circumstances involved in the marriage, is not going to be able to leave from this marriage and support himself or herself, or will come out of this marriage being treated inequitably. Now, there are many circumstances where this can occur, in many ways it occurs, but And once again, there are no guidelines, there are no set figures, say if you make this much, you're entitled to maintenance, so forth. That is strictly up to the discretion of the court, and is up to your attorney to present that to the court for proof. In my opinion and experience, probably the most volatile issue of no-fault divorce is child custody and support. These items, specifically the idea of custody, can be the most hotly contested and the most emotional, where people sometimes lose their rationality. It's not a matter of who's right and who's wrong. It's just a matter of, it's my child and that's the way it's got to be. And once again, if you go in with that attitude, it causes problems. It does not help the process, and eventually is not good for the child. It's harmful for the child. The court in Kentucky has determined that there is no preference for father or mother as relates to custody, that each case stands on its own. Each parent has the right to petition the court for custody of the child, and each parent has the right, absolute right, to visitation with that child, no matter which side gets custody. That is something that must be kept in mind. No matter who is going to get custody, the other side will have certain visitation rights. At the same time, whoever does not have custody of the child has an obligation to support the child. In the past, many courts have allowed this support obligation to be set aside in favor of possible other items. They will let you bargain that away. It is becoming more and more apparent in this court, in the 15th Judicial District, and in other districts, that the court will not let you bargain that away, that the right to support is the right of the child and not that of the custodial parent, and will not let you bargain that away. Support will be collected for the benefit of the child. And also, in that same line, the state has published guidelines which dictate how much support will be paid per child. And this is simply a formula by which you put in both parents' income and child care costs and insurance costs, and it gives you a figure that is the recommended support for income levels that you now have. This is reviewable by the court on a regular basis, and dependent upon how often there may be changes in circumstance, if one parent loses his or her job or has a great increase in his or her income, then that is reviewable by the court and can't be changed regularly. What I have intended to do, and what we are doing here, is certainly not answer all the questions you may have, but rather give you an overview of what issues need to be decided and what you may need to think about before you seek the advice of an attorney. Once you decide to take that step, then I would ask Mr. Young here to tell you what procedures then must be followed to get a no-fault divorce. Mike?
Thank you.